Hello everyone. Today we are going to discuss the topic types of companies in India, detailed breakdown. That is in the companies law, right? So today we are going to discuss types of companies in India, right? Detailed breakdown in company law. So let us start with the topic types of companies in India and its breakdown. A company is an incorporated association of persons created by law to carry on the expressly laid down objectives. Right? A company exists on in contemplation of law. Right? A company exists on in the contemplation of law. It may be formed by an act of parliament or by royal charter or by registration under the company law. A company has perpetual existence, right? That is, the existence of company can only be terminated by law and not by death, retirement, insanity of its member, right? So let us study the types of companies in India, right? There are two types of company: statutory company, registered company. So let us see what do we mean by statutory company. The first type of company in India is company formed by special act passed either by the central or the state legislature. It's called a statutory company, right? Either by central or state legislature. So that will be statutory company, right? These type of companies are governed by the provisions of their special acts, right? The companies are usually formed to carry out some special public undertaking. The object of such companies are not to as such earn profit, but to serve people. The audit of such companies is conducted under the supervision and control and guidance of the Controller and Auditor General of India, right? Some important statutory companies are Reserve Bank of India, State Bank of India, Life Insurance Corporation of India, Industrial Finance Corporation, etc. Right? Let's move further. What do we mean by registered company? A company registered under the Indian Companies Act is known as registered company. These type of companies are governed and regulated by the provision of Companies Act 2013. They may be limited by shares or limited by guarantee or unlimited companies, right? So the kind of companies on the basis of liability of members, right? So let us see. Company limited by shares. So this is a type of firm in India having the liability of its member limited by memorandum to the amount unpaid on shares. So it is limited to the amount unpaid of shares respectively held by them. A large majority of companies registered in India belong to this category. The last word of the name of the such company should be limited. So we can identify with the help of this thing, limited. For example, AB Limited has a share capital of 10,000 shares of ₹0 each, and A has purchased 100 shares on which he has paid so far 6 per share, right? The maximum liability of A is only ₹4 per share. Okay. The company is limited by guarantee. This is a type of firm in India in which the liability of each member is limited to such amount as the members may voluntarily undertake under the memorandum to contribute to meet out the deficiency of asset of the company in the event of its being wound up, right? Such type of firms in India may or may not have share capital. If it has a share capital, the liability of share members become twofolded. First, the amount unpaid on the shares held by them. Secondly, amount payable under the guarantee, right? So they are the two. So the liability that is twofold. First is amount unpaid on the shares, the amount which is unpaid and held by them, and secondly, amount payable under the guarantee. So whatever amount they have guaranteed, so that amount, right? Let's move further. Unlimited companies. A company not having any limit towards let us see, it's unlimited company. So a company not having any limit towards the liability of its members is an unlimited company, right? The liability extends to whole amount of the company's debt and liabilities. The registered companies, whether limited or unlimited, may be either private or public companies, right? So let us see. Private limited company. Private limited company is held by few individuals privately having separate legal entity. In this, shareholders cannot trade shares publicly. Shareholders cannot sell their shares without the approval of other shareholders. It is a company which restricts the right of its member to transfer its shares, and it does not send invitation to public for subscription of its shares, right? Characteristics of the private limited company. So So these are the characteristics of a private limited company. So let us start with it. First, how many members are required? It is to start a company, a minimum number of 2 members are required, and a maximum 200 members as per the provision of the Companies Act 2013. So the minimum is 2 and the maximum 200 members. Index of members: a private company has a privilege over the public company, as they don't have to keep an index of its members, whereas the public company is required to maintain the index of its members, right? So that is index of members. Private company doesn't need to maintain it, but the public company is required to maintain, right? Exemptions regarding directors: when it comes to directors, a private company needs to have only 2 directors, right? With the existence of 2 directors, a private company can come into operation. Also, private company need not appoint independent directors. The maximum number of companies of which a person may be appointed as a director is 20 in case of private company, right? So that is the maximum number is 20, right? Paid up capital: it must have minimum paid up capital of rupees 1 lakh or such higher amount which may be prescribed from time to time. So the minimum is 1 lakh rupees. Prospectus is a detailed statement of the company affairs which is issued by a company for its public. However, in case of private limited company, there is no such need to issue a prospectus, because in this public is not invited to subscribe for the share of the company, right? And name: it is mandatory for all private companies to use the word private limited after its name. Okay. In the case, if any private limited company does not follow any of the above mentioned features, it ceases to be private company, right? Let us see what do we mean by public company. A public limited company is a form of business organization that operate as a separate legal entity from its owner, right? It is a separate legal entity from its owner. It is formed and owned by shareholders, right? Share of a public limited company are listed and traded at a stock exchange market freely, right? So the shares of a public limited company are listed and traded at stock exchange market freely, right? Let's move further. Characteristics of a public company. So these are the characteristics of a public company. It must have minimum 7 members, right? And no limit with regard to the maximum number of members. So the minimum is 7, and there is no maximum limit for the the minimum is 7, but there is no limit for the maximum number of members, right? The minimum, there should be at least 7 members, right? The share of public company are freely transferable, so the shares can be freely transferred. It can invite public to subscribe to its share or purchase its share, right? It must constitute an audit committee of the board, right? So there should be a constitution of audit committee, right? It must be constituted in a public company. So let us see what do we mean by one-person company. This is a type of company that has only one member, right? One person company provides the benefit of both forms of business, proprietorship and company, right? So it provides in this one person company, in this we have both the forms, proprietorship and company, right? With the formation of one person company, business can be run in the same way as proprietorship by complying with law and keeping the liability of members limited by shares or guarantee, right? Provision of one person company under Companies Act 2013. All the provision of the act applicable to private companies shall also be applicable to one person company unless otherwise excluded from compliance, right? So the provision of the act is applicable to private companies also, right? All the provisions of the act applicable to private companies shall also be applicable to one person company, right? It should be treated as private company for all legal purposes, okay? The name of the company shall include the word one person company with bracket below the name of the company. So it should be clearly written one person company, right? Below, in brackets, below the name of the company. The person forming one person company has to nominate a person with that person written consent as a nominee of the one person company, right? So there should be nominee, right? So one person company has to nominate a person with that person's written consent as a nominee of the one person company. It should have a maximum 15 directors. So the maximum directors that can be in one person company is 15, and they are not required to retire by rotation, okay? Holding and subsidiary company. So what do we mean by holding and subsidiary company? A company which controls another company is called a holding company, and the company so controlled is called subsidiary company, right? Which has control which controls another company, that is holding company. right? And the company so controlled, and the company which is being controlled is a subsidiary company. A company shall be deemed to control another company in the following cases: if it controls the majority of the board of directors, right, of another company, if there is a majority, if there is a control upon the majority of the board of directors of another company, right? If it exercises control more than one half of the total share capital, right? If it exercises control on more than one half of the total one half of the total share capital, either at its own or together with one or more of its subsidiary companies, right? So if there is a control, right, control on more than one half of the total share capital, either at its own or together with one or more of its subsidiary companies, right? If another company is a subsidiary of first mentioned company's subsidiary of the subsidiary, right? So subsidiary company, right? So that will be also, so that will be called control. That will be a company shall be deemed to be deemed to control another company, right? Subsidiary company, right? Okay. So that will be a company. So that will be deemed to control another company. Okay. Let's move further. So what do we mean by associate company? Associate company, as in relation to another company, means a company in which that other company has a significant influence, but which is not a subsidiary company of the company, right? Such influence and includes a joint venture company, right? Significant influence means control of at least 20% of total share capital. So if there is control of at least 20% of total share capital, but less than 50% of share capital, so that should be more than 20%, but less than 50%, right, of share capital by another company, or control of business decisions under an agreement. So that will be an associate company, right? So let's see, what do we mean by small company? Small company means a company other than a public company, right? So it is a company other than a public company. So these are the following characteristics of small company. Paid up share capital does not exceed 50 lakh or higher amount as may be prescribed. So the paid up capital does not exceed 50 lakh rupees. Turnover of which, as per the profit and loss account, does not exceed 2 crore. So the profit and loss, the turnover does not exceed 2 crore or such higher amount as may be prescribed. However, a small company cannot be a holding or subsidiary company. So this is the important characteristics with the help of which we can identify whether it is a small company, right? It says a small company cannot be a holding or subsidiary company. So it cannot be a holding or subsidiary company, right? A company registered under Section 8 of the right? So it cannot be a company which is registered under Section 8 of the 2013 Act, right? A company or body corporate governed under any special act. So it should not be a company or body corporate under any special act, right? Let us see what are the exemptions of a small company. Financial statement may not include the cash flow statement. So these are the exemptions. So these are the exemptions which has been provided to a small company, right? So financial statement may not include the cash flow statement. So there is not going to be any cash flow statement, right, in the financial statement. The annual return shall be filed by director and company secretary, or whether there is no company secretary, by two directors, right? So the annual return shall be filed by the director, right, and company secretary. So it will be filed by director and company secretary, and if there is no company secretary, then by two directors, right? It is sufficient if at least one meeting of the board of director has been conducted in each half of a calendar year. So in each half of a calendar year, there should be at least one meeting of board of directors, right? Government company. A government company means any company in which not less than 51% of share capital is held by central government and state government, right? Partly by central government and partly by one or more state government. It also includes a company which is subsidiary of government company, right? So these are the characteristics of a government company, right? Let us see the special provisions regarding this government company. The auditor of a government company shall be appointed or reappointed by central government on the advice of Controller and Auditor General of India, right? So it being a government company, right? So here the auditor, right, the auditor of a government company shall be appointed or reappointed by the central government on the advice of Controller and Auditor General of India, right? The Auditor General will have the power to direct the company's auditor relating to the manner of audit and the performance of his duties. The manner of audit and the performance of his duties, right? He shall also have the power to conduct a supplementary test audit of company's account, right, by persons appointed by him, right. So he says, it says he shall also have the power to conduct a supplementary test of the company's account, right, by person appointed by him, and the auditor is required to submit a copy of his audit, right, and the auditor is also required to submit a copy of his audit report to the controller and auditor general, who shall have the right to comment upon the report, right. So he may also comment upon the report. Where the central government is member of a government company, right. So where there is a central government, a member is a member of government company, the central government shall prepare an annual report of the working and affairs of the company within 3 months of its annual general meeting, before which the audit report is placed, right. So the central government shall prepare annual report on the working and affairs of the company, right, within 3 months of its annual general meeting, before which the audit report is placed, right. The annual report is to be laid before both House of Parliament together with a copy of the audit report, right. So it will be placed before, so this annual report will be placed before both houses of Parliament, right, together with a copy of the audit report, right. So let us see what do we mean by foreign company. A foreign company is a company incorporated outside India, right. So it means on any company which is incorporated outside India has a place of business in India. So it has a place of business that is in India, whether by itself, either it is by itself, through an agent. There may be an agent physically or through electronic mode, right. Even if a company is, like this, that is set up in foreign country, right, but the business operation, right, business in India, that may be either through an agent physically or through electronic mode, right, conducts any business in India in any other manner. So it may conduct any business activity in India in any other manner, right. But the key point is that the company is registered outside. A company, as it is written, as we can see, the important point, foreign company is a company incorporated outside India, right. So it should be incorporated, established outside India, right. So let us see what do we mean by producer company. If it means a body corporate having object or activity specified in section 581B and deals primarily with the produce of its active members. So it primarily deals with the produce of its active members for carrying out any of its specified objects, right. The object of producer companies shall include one or more of the 11 items specified in the act, and the more important being production, harvesting, procurement, grading, pooling, handling, marketing, selling, export of primary produce of members, or import of goods or services for their benefit, right. Processing including preserving, drying, distilling, brewing, venting, canning, and packing of produce of its members, right. And manufacture, sale, or supply of machinery, equipment, or consumables mainly to its members, right. Rendering technical or consultancy services, generation, transmission, distribution of power, revitalization of land and water resources, right. Promoting techniques of mutuality and mutual assistance, right. Welfare measures, and providing education on mutual assistance principles, right. Let's move further. Now let us see what do we mean by this is dormant company. So dormant company, where a company is formed and registered under this act for a future project, right. So it says where a company which is formed and registered under this Companies Act, right, for a future project, right. So that project is not in existence, so that is for a future project, or to hold an asset, right, or to hold an asset or intellectual property. It is either to hold an asset or intellectual property, and has no significant accounting transaction, and it has no significant accounting transaction, right. Such a company or an inactive company may make an application to registrar in such manner as may be prescribed for obtaining the status of a dormant company, okay. So inactive company means a company which has not been carrying on any business or operation, or has not made any significant accounting transaction during the last 2 financial years, or has not filed financial statement and annual returns during the last 2 financial years, right. So this is what is inactive company means. A company which has not been carrying on any business, so it is not carrying on any business or operation, or has not made any significant accounting transactions. So there is no significant accounting transaction, right, during the last 2 financial years. So it is for 2 financial years. If there is no business activity, there is no there has been which has not been carrying on business or operation, right, or has not made any significant accounting transactions during the last 2 financial years, means during the last 2 financial years, or has not filed financial statements, it has and or has not filed financial statements, right, and annual returns during the last 2 financial years. So the key word is 2 financial years. During last 2 financial years, if the above activities have not been done, if these things have not been carried on, so then it will be called an inactive company, right? Where a dormant where a, as and the dormant company means where a company is formed and registered under this act for a future project, right, or to hold an asset or intellectual property and has no significant accounting transaction, right? Such a company or an inactive company may make an application to register in such manner as may be prescribed for obtaining the status of a dormant company, right? So with this, we have come to the end of this topic, right? Thank you very much.